The second challenge is to the combination of counts 5 and 9. And let me get my indictment back up. Count 5 charges felony murder premised upon count 9. And of course, we know that felony murder, and I'll get the definition of that, is in 1651C. A person commits the offense of murder when in the commission of a felony, he or she causes the death of another human being irrespective of malice. So we can forget all of what I just said about malice because it doesn't apply here. The state would have to prove the underlying felony and then show a causal connection, proximate cause, between that underlying felony and the unintended death without malice. And in this case, count 9 is the criminal attempt to commit a felony, namely false imprisonment, on, let's see if it says it in here, Burford Drive. Count 9, then, as we know, is the allegation that on Burford Drive, the beginning of the encounter with Ahmaud Arbery, that Travis and Greg McMichael, along with Roddy Bryan, but I'll leave his lawyer to argue his case here, but that Travis and Greg McMichael, using their Ford F-150, attempted to commit the crime of false imprisonment. And then they combined that with count 5 to say that that's a felony murder premised upon that attempted felony on Burford Drive. Well, the causal link between the attempt to falsely imprison someone 3 or 4 minutes before shooting them with a shotgun is just too tenuous to support, under the proximate cause analysis, a felony murder charge in count 5. I'm not saying that count 9 can't stand and be presented to the jury, but when you combine it with count 5 as the underlying felony for felony murder, what we're facing then is a complete lack of a causal link. I mean, you can add several links to get to Holmes Road where the shooting occurs, but there is nothing about the attempt to false imprison Ahmaud Arbery on Burford Drive with a pickup truck, particularly Travis McMichael's Ford F-150, and his ultimate death on Holmes Road. And if you try to do it by party to the crime, 16220, and connect Travis and Greg McMichael to William Roddy Bryan, as that count does, because it also names him in count 9, names his truck, his Chevy Silverado, in count 9, and then connects them both back to count 5 for felony murder. But 16220, party to the crime statute, I'll read, it's not long. Every person concerned in the commission of a crime is a party thereto and may be charged with and convicted of commission of the crime. B, a person is concerned in the commission of the crime only if he, 1, directly commits the crime. And here we're talking about directly commits the crime of criminal attempt to falsely imprison Ahmaud Arbery on Burford Drive. And he didn't, that is, Travis and Greg McMichael, didn't directly commit that crime with a Chevy Silverado. And then 2, intentionally causes some other person to commit the crime. That doesn't apply here. No one's causing anyone else to commit any crimes. 3, intentionally aids or abets in the commission of the crime. That is, proof that Travis and Greg McMichael are intentionally aiding or abetting Roddy Bryan in the commission of the crime of attempting to false imprison Ahmaud Arbery on Burford Drive. And then finally, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. So as the evidence was produced here in this case, Roddy Bryan saw the white truck and saw Ahmaud Arbery, made some driveway assumptions according to Ms. Dunikoski, and then went and got in his truck to do what he did. But as we heard, he hollered something that the McMichaels did not hear. The evidence from the state was uncontroverted that whatever he said, there was no indication, no evidence whatsoever that the McMichaels heard it. There was no phone communication of any kind between either McMichael's phones or Roddy Bryan's phones. In short, there was no coordination, there was no participation, no planning, no intentionally aiding and abetting, or intentionally advising, encouraging, and so forth between the two McMichaels and Roddy Bryan on Burford Drive, where count 9 concerns my argument here. So the criminal attempt to commit false imprisonment, if that arguably occurred by the McMichaels with their F-150 on Burford Drive, fails to support count 5's felony murder because of the tenuous causal link, approximate causal chain that's just not going to reach. And secondly, if it's a party to the crime theory, there's no evidence at all that there was any participation, intentional, and that's a key word in the party statute, between the McMichaels and Roddy Bryan on Burford Drive. So that's my directed verdict argument to count 5, and I make it in connection with count 9. And yet I am conceding that count 9 could survive a directed verdict and be presented to a jury. There is a conflict in the evidence there about what the McMichaels were doing on Burford. Obviously, we're saying that excuse me, that they're attempting to make a citizen's arrest. The state says they're attempting to do a false imprisonment. That's a legitimate jury issue. But connecting it to count 5 felony murder, that should be directed in favor of the defendants as an acquittal. All right, my third attack here under the motion for directed verdict of acquittal will be the combination of counts 3 and 7. Again, count 3 is a felony murder count, and it refers to the allegation in count 7. And when you go to count 7, the argument there is that the defendants committed an aggravated assault with a Ford F-150 and a Chevy Silverado, which they allege are objects, devices, and instruments which, when used offensively against a person, are likely to result in serious bodily injury contrary to our laws. But then they connect it to murder in count 3. Again, however the trucks were used in this case by the McMichaels, the trucks were used, yes, to attempt to detain, to block in, to trap Ahmaud Arbery. But again, the argument here will be for the purposes of citizen's arrest, not for the purpose of falsely imprisoning him or assaulting him with a truck. But more than that, that would be a legitimate jury issue in count 7. But in count 3, neither truck was the causal link in the death of Ahmaud Arbery. It was the means by which to get to the place where the death ultimately occurred, of course. It was the conveyance in which the defendants rode. But the truck itself did nothing to cause a serious bodily injury or death, at least the Ford F-150. And this is not alleging in count 7 that Ahmaud Arbery received some injury when he encountered Roddy Bryan's truck on Burford Drive. That's not alleged in this indictment anywhere, even though there's some evidence of contact between him and that truck on Burford Drive. This count is actually not saying anything about that, but connecting it back to count 3, felony murder. So it's the same problem as we just had in counts 5 and 9. It's a failure of a causal link, no proximate cause to show that the truck is connected to the murder in a causative way, and the same with party to the crime. The other thing this combination of counts does, it doesn't say whether this aggravated assault with a truck is occurring on Burford Road or Holmes Drive. We're left to guess which it is. It simply does not specify. Now that's a demur type issue, and that may have been addressed earlier, but here for directed verdict, if the allegation is that the felony murder occurred on Holmes by use of the truck on Holmes, well, the undisputed evidence in the case is while the truck got driven to Holmes Drive, when we see the video, it's undisputed that the truck is parked, the driver is out of it, the truck is not moving, and it bears no connection at all except as a device around which the defendant stood, one Greg McMichael in the back of the truck, Travis out of the truck, and Ahmaud Arbery going around the truck. So the truck is not a causal element in the death of Ahmaud Arbery, and therefore count 3 should be directed as a verdict of acquittal for the defendants. Count 4 and 8 are connected. 4 is felony murder, referring to the allegations in count 8. Count 8 is the false imprisonment allegation, this time on Holmes Drive. And Holmes Drive, of course, is the final place where the events transpired and the tragedy occurred. But this count 8 alleges that on Holmes Drive, using the 2 pickup trucks, the 3 defendants in concert with one another as parties to the crime, falsely imprisoned Ahmaud Arbery, and then the shooting occurs and they make the causal link back to count 4 for the felony murder charge. But again, the evidence in the case was that there was no place on Holmes Drive where the truck was used to block in Ahmaud Arbery. Where the truck is finally parked, as Agent Dial testified yesterday, I believe, under cross-examination with Kevin Goff, he conceded that there were escape routes. There were places Ahmaud Arbery could have chosen to run through yards, across a yard and onto Satilla Drive if he had chosen to. So how one can be falsely imprisoned when the case agent is testifying under oath that he could have kept on running. The truck itself did not impede his decision to turn right and run across this yard onto Satilla Drive and continue down Satilla Drive until he left the neighborhood, or until he encountered the police, which we also have heard with undisputed evidence was on Satilla Drive when the shooting occurred. So he would have run into a police car at the very least, and then possibly Matt Albenzi if that police car was not where the undisputed evidence says it was. So again, count 4 felony murder should fail because it's based on count 8, which count 8, it's fair enough to send to the jury. It's a disputed allegation, but count 4 can't be supported by it. Finally, counts 2 and 6 are connected, and our motion applies to them in this way. Count 2 is a felony murder, this time premised upon count 6, and count 6 is the allegation of aggravated assault with the use of a shotgun, a firearm, a deadly weapon, to wit, a 12-gauge shotgun. This one's a little stickier in this regard because the evidence has come out that Travis McMichael pointed his shotgun at Ahmaud Arbery on 2 separate occasions. There's been evidence presented by the state that as Ahmaud Arbery is running towards the back of the pickup truck, on the driver's side of the truck, Travis McMichael raises his shotgun, and then he lowers it and moves to the left front quarter of the truck as Ahmaud Arbery makes a couple of weaving maneuvers and then comes around the right side of the truck, and then the gun is raised again and this time discharged, and those shots are what were fatal to Ahmaud Arbery. The count does not specify here in count 6 which of those 2 gun raisings is the aggravated assault. Certainly the first one, where no discharge occurred, could not therefore have been the cause of death, and it could not support count 2 felony murder since there was no discharge of a deadly shot from the shotgun. And because the count doesn't specify, applying the rule of lenity, this should be read as applying to that, because that by itself could be charged as an aggravated assault. Had the case stopped right there, had Ahmaud Arbery stopped in his tracks, and the state had chosen to say, well, this is no citizen's arrest, this is just a garden variety aggravated assault. You're pointing a shotgun at somebody for no good reason. You didn't discharge it, you didn't kill him, but it still could be charged as an aggravated assault. Well, it certainly couldn't be ever, under those circumstances, the underlying felony for a felony murder if the guy was still alive, if no shot had been fired. So that aggravated assault, though, is still in play. It's been put in evidence. It's not charged in the indictment, or is it? We can't tell from count 6, because count 6 only refers to one act of aggravated assault with a shotgun. And I guess the jury will be left to presume that it's the second pointing that results in the shooting, which results in the death, which results in the felony murder of count 2. Those are my arguments, Your Honor, for a directed verdict on counts 1, 2, 3, 4, and 5.